Good day, everyone, especially to you, Dr. Jeah. My name is Jeah Rojo, and today we're going to talk about the Chapter 12, which is the laws related to tourism, investments, and finance. So, before anything else, I'm going to be providing to you first the topic outline and the objectives of this chapter. So, for our topic outline, we do have the Foreign Investments Act of 1991 with the limitations of foreign ownership, investment in transportation business and public utilities, investment in travel agencies and tour operators, investment in hotels, resorts, and other accommodation establishments, application of the retail trade law for restaurants and shops, tourism projects under the Build, Operate, and Transfer or BOT program, and applicable negotiable instruments and documents of title and the other commercial documents. So for our objectives, we are expected to learn this by the end of the topic, which is to enumerate the procedure in setting up a tourism-oriented business, to explain the laws governing tourism investments and financing tourism-oriented projects, to discuss the business models applicable to tourism projects, to enumerate the various taxes applicable to tourism-related establishments, and to discuss the limitation of foreigners in tourism investments. So the tourism industry plays a pivotal role in the Philippine economy, and the government actively encourages its growth by providing incentives and establishing regulatory frameworks. So this report delves into the laws related to tourism investments and finance in the country, primarily focusing on Republic Act 7042 as amended by Republic Act 8179, also known as the Foreign Investment Acts of 1991. This legislation outlines the extent of foreign investors' participation in various tourism-related enterprises, including accommodation facilities, travel agencies, and transportation services. So this report will discuss the limitations on foreign ownership, the procedures for setting up tourism-oriented businesses, and the applicability of other relevant laws such as the Retail Trade Liberalization Act of 2000 and the Build, Operate, and Transfer or BOT law. So by examining these legal frameworks, this report aims to provide a comprehensive overview of the regulations governing tourism investments and finance in the Philippines. So Foreign Investments Act of 1991. So under this is the Republic Act 7042, which is amended by Republic Act 8179 that allows foreigners to invest in all activities and enterprises in the Philippines except those in the negative list. So foreign investors must determine the type of enterprise, may it be domestic market enterprise or export enterprise. So for domestic market enterprise, it produces goods for sale or renders services to the domestic market. Foreigners can invest up to 100% equity except in areas in the negative list or if paid-in equity capital is less than $200,000, unless it involves advanced technology or employs at least 50 direct employees, in which case a minimum paid-in capital of $100,000 is allowed. So for export enterprise, exports are 60% or more of its output. So there are no restrictions on foreign ownership up to 100% unless the products or services are in negative lists A and B or use raw materials from depleting natural resources. So for the procedure for registration, so for corporations and partnerships, they need to file with the Securities and Exchange Commission or SEC. And for sole proprietorships, they need to file with the Bureau of Trade Regulation and Consumer Protection or BTRCP of the Department of Trade and Industry. And foreign corporations must also secure a license from the SEC to do business in the Philippines. So effects of non-compliance, there will be administrative sanctions like fines, forfeiture of benefits. And for foreign corporations, criminal liability like fine or imprisonment, and an inability to sue in Philippine courts but can be sued. The limitations of foreign ownership. So under the Executive Order number 139 lists investments with the foreign ownership limitations. So for list A, foreign ownership is limited by the Constitution and the specific laws like mass media, services involving licensed professions, and retail trades. So for list B, foreign ownership is limited for reasons of security, defense, risk to health and morals, and protection of small and medium-scale enterprises like manufacture of firearms, sauna and steam bathhouses, domestic market enterprises with paid-in equity capital of less than $200,000. So the specific limits include that no foreign equity, mass media, practice of licensed professions, retail trade, and etc. Second is up to 25% foreign equity with a private recruitment. Third is up to 30% foreign equity with advertising. And lastly, up to 40% foreign equity with natural resources exploration, ownership of private islands or private lands, and operation of public utilities, and etc. So investment in transportation, business, and public utilities. So the operation of public utilities, including air, land, and water transportation, requires a franchise certificate or authorization. So these are granted only to citizens of the Philippines and corporations or associations organized under Philippine laws with at least 60% of capital owned by such citizens. And also, foreign participation is limited up to 40%, and executive and managing officers must be Filipino citizens. So for investments in travel agencies and tour operators. So applicants for accreditation as a tour operator must be first, a resident Filipino citizen. Second, a partnership organized under Philippine laws with at least 60% of its capital owned by Filipino citizens. And lastly, corporations organized under Philippine laws with at least 60% of subscribed common or voting shares owned by Filipino citizens, and at least 60% of the board of directors are Filipinos. And also, under the investment in travel agencies and tour operators, foreign participation is limited to 40%. Tourism also is classified as a preferred activity under the Omnibus Investment Code of 1987, and it is to be entitled for registration under the Investment Priorities Plan, and an applicant must satisfy the Board on Investments that, first, if the applicant is a natural person, he is a citizen of the Philippines, or if a partnership or any other association and it is organized under the Philippine laws, and that at least 60% of its capital is owned and controlled by citizens of the Philippines, or in case of a corporation or a cooperative, it is organized under the Philippine laws, and that at least 60% of the capital stock outstanding and entitled to vote is owned and held by the Philippine nationals as defined under the members of the board of directors that are citizens of the Philippines. Also, the second is the applicant is proposing to engage in preferred project listed or authorized in the current investment priorities plan within a reasonable time to be flexible by the board. And lastly, the applicant is capable of operating on a sound and efficient basis of contributing to the national development of the preferred area in particular and of the national economy in general. So next is the investment in hotels, resorts, and other accommodation establishments. So tourism is classified as a preferred activity under the Omnibus Investment Code of 1987. So this includes the development of tourism economic zones, tourist estates, eco-agritourism facilities, and tourist accommodation facilities like hotels, resorts, hotels, pension houses, tourist inns, and etc. So to be entitled for registration under the Investment Priorities Plan, an applicant must satisfy the Board on Investments that, first, he is a citizen of the Philippines, and in case the applicant is a natural person or in case of a partnership or any other association, it is organized under the Philippine laws, and that at least 60% of its capital is owned and controlled by citizens of the Philippines. Or, in case of a corporation or a cooperative, it is organized under the Philippine laws, and that at least 60% of the capital stock outstanding and entitled to vote is owned and held by the Philippine nationals as defined under the Article 15 of Omnibus Investment Code, and at least 60% of the members of the board directors are citizens of the Philippines. Next is the applicant is proposing to engage in a preferred project listed or authorized in the current investment priorities plan within a reasonable time to be fixed by the board. And third is the applicant is capable of operating on a sound and efficient basis of contributing to the national development of the preferred area in particular and of the national economy in general. So for hotel investments, 60% of the capitalization should be owned by Filipinos. So next is we do have the application of the retail trade law for restaurants and shops. So restaurants and other tourism-related establishments like department stores and shops are governed by retail trade laws. So, the Retail Trade Liberalization Act of 2000 allows foreign investors to engage in retail trade subjects to capital requirements. So, accepted sales transactions allowed 100% foreign ownership must first sales by a manufacturer, processor, laborer, or worker of their products if their capital does not exceed 100,000 pesos. Next is sales by a manufacturer of their products in a single outlet, irrespective of capitalization. And lastly, sales in restaurants incidental to the hotel business. Next is the tourism projects under the Build, Operate, and Transfer or BOT program. So, Republic Act number 6987, as amended by Republic Act 7718 or the BOT law, aims to recognize the role of the private sector in national growth and development. So, it covers the government infrastructure projects and government development projects. So, schemes under the BOT law is the Build and Transfer or BT. It is a project proponent finances and constructs a facility, then turns it over to the agency or LGU concerned, which pays the project proponent. Next is we also do have the Build, Lease, and Transfer or the BLT. The project proponent finances and constructs a facility, turns it over to the agency or LGU in a lease arrangement, and ownership is automatically transferred after a fixed period. Third is we do have the Build, Own, and Operate or BOO. The project proponent finances, constructs, owns, operates, and maintains a facility, recovering costs through user fees, subject to NEDA Investment Coordination Committee or ICC approval and presidential approval. Fourth is we do have the Build, Operate, and Transfer or BOT. So project proponent constructs, finances, operates, and maintains a facility for a fixed term up to 50 years, charging users appropriate fees to recover investments and expenses, then transfers the facility to the agency or LGU. So this includes a supply and operate scheme involving technology transfer and training to Filipinos. Fifth is we do have the Build, Transfer, and Operate or BTO. So the agency or LGU contracts out of the construction of a facility to a private entity, which builds it on a turnkey basis. Title is transferred to the agency or LGU once commissioned, but the private entity operates it. Six is we do have the Contract Add and Operate or CAO. The project proponent adds to an existing facility rented from the government and operates the expanded project. Seventh is a Develop, Operate, and Transfer or DOT. The project proponent develops adjoining property to a new infrastructure project and benefits from the investment, like higher property values. Eighth also is to Rehabilitate, Operate, and Transfer or ROT. It is an existing facility that is turned over to the project proponent to refurbish, operate, and maintain for a franchise period, after which the title is turned over to the government. And lastly, we do have the Rehabilitate, Own, and Operate or ROO, which is an existing facility that is turned over to the project proponent to refurbish and operate with no time limitation on ownership, as long as the operator is not in violation of its franchise, and it can continue to operate the facility in perpetuity. So for that, we do have the qualification requirements. First is any individual, joint venture, or consortium of local, foreign, or local and foreign firms may participate. Also, for BOT projects requiring a public utility franchise, the project proponent and facility operator must be Filipinos, or if corporations, must be SEC registered and at least 60% Filipino-owned. For other projects, nationality and ownership requirements under the Constitution and other laws apply. Third is for schemes other than BOT requiring a public utility franchise, the facility operator must be Filipino, or if a corporation, SEC registered and at least 60% Filipino-owned. The project proponent may be the operator but can have a management contract with another entity, even 100% foreign-owned, for day-to-day operation, provided the project proponent has all liabilities. Next is in joint ventures or consortia, members must be disclosed during pre-qualification and are jointly and severally or severally liable. So if members from a Philippine registered corporation, that corporation will also be liable. Fifth is for projects operated by the project proponent or owned by the project proponent but operated through a facility operator where operation of the facility does not require a public utility franchise. The project proponent or the facility operator may be Filipino or foreign owned. Six is the contractor must be duly licensed and accredited by the Philippine Contractors Accreditation Board or PCAB for Filipino contractors by an equivalent accreditation institution in the contractor's country of origin and in the case of a foreign contractor. Seventh, foreign contractors must secure a license and accreditation from the PCAB once the project proponent is awarded the project. Eighth, the prospective project proponent must possess adequate experience in terms of firm experience and key personal experience. And lastly, the prospective project proponent must have adequate capability to sustain the financing requirements for the detailed engineering design, construction and/or operation and maintenance phases of the project as the case may be. So for period covered, the contractor transfers the facility to the government unit concerned at the end of the fixed term, which will not exceed 50 years. So for financing, it is allowed that for the construction stage, the contractor may obtain financing from foreign or domestic sources or engage the services of a foreign or Filipino contractor. Second is the financing of a foreign or foreign-controlled contractor from Philippine government financing institutions shall not exceed 20% of the total cost of the infrastructure, facility, or project. And lastly, financing from foreign sources shall not require as a guarantee by the government or by government-owned and controlled corporations. So for employment of Filipino workers, in the case of foreign contractors, Filipino labor shall be employed or hired in the different phases of the construction where Filipino skills are available. So for priority projects, all concerned infrastructure agencies, including government-owned and controlled corporations and local government units, shall include in their infrastructure programs those priority projects that may be financed, constructed, operated, and maintained by the private sector. And also under Joint Resolution Number 3 passed by the Congress, the following have been classified as national priority infrastructure projects related to tourism. For A, it includes highways, including expressways, roads, bridges, interchanges, tunnels, and related facilities. For the Section B, rail-based projects packaged with commercial development opportunities like use of government facilities. So, in conclusion, the legal landscape surrounding tourism investments and finance in the Philippines is structured to balance the attraction of foreign capital with the protection of national interests and the promotion of local participation. So, the Foreign Investment Acts of 1991, along with other pertinent laws and regulations, establishes clear guidelines for foreign ownership in various tourism sectors, ensuring that Filipino citizens and businesses maintain a significant stake in the industry. Furthermore, mechanisms like the BOT law facilitates public-private partnerships in developing crucial tourism infrastructure, contributing to the overall growth and sustainability of the sector. So, by adhering to these legal frameworks and promoting transparency and fair practices, the Philippines can continue to foster a conducive environment for tourism investments, thereby maximizing its potential to benefit the national economy and local communities. So, that would be all for my report. I hope you have learned something and thank you so much for listening. Have a great day.